What can happen if an SBA loan obligor omitted or falsified information in the SBA loan application or the SBA offer in compromise? Engaging in fraud may trigger an investigation by the SBA Office of Inspector General and U.S. Department of Justice. One of the most concerning factors an SBA debtor needs to be wary of is submitting a false statement or making a material omission in documents submitted to the SBA. Many problems can occur if false representations or omissions are made in workout documents submitted to the SBA lender, CDC, or the SBA. These may include the SBA offer in compromise forms, for example, Forms 1150 and 770, and signed under 18 U.S.C. Section 1001. Additionally, problems can occur if the SBA reviews the SBA loan application and discovers false representations or omissions in certain forms, for example, Form 912, that you initially submitted in order to obtain the subject loan through the SBA loan program. If you face any of these scenarios, you may eventually become a target of the SBA Office of Inspector General and the U.S. Department of Justice. What is a target letter from the U.S. Department of Justice? A target letter is notice that you are under investigation for suspected violations of federal law. More aptly, the investigation is probably largely concluded upon your receipt of the notice having been delivered by a federal agent. The letter is issued by a DOJ prosecution entity like a litigating division at Main Justice or any of the 94 United States Attorney's offices, all of whom have the Attorney General's delegated authority to indict and prosecute targets. The letter provides the general nature of the charges, often by citation to specific United States Code sections indicating the federal law that assistant U.S. attorneys believe were broken, inadvertently or otherwise. The letter explains further that the addressee is a target with exposure for being prosecuted for violations of federal law, as opposed to a witness or subject, and believed to have information helpful to an investigation, but not considered culpable for the actual offense. The letter explains the target's constitutional rights against self-incrimination and to representation by counsel under the United States Constitution's Fifth and Sixth Amendments. The letter provides a specific response time and identifies the assistant U.S. attorney, and sometimes the federal agency, investigating the alleged offenses. Because the investigation is largely concluded before the target letter is signed, sealed, and delivered, the assistant U.S. attorney could have taken the collected evidence and appeared before a grand jury to seek an indictment. Instead, the assistant U.S. attorney issued the target letter, which implies the assistant U.S. attorney's desire to resolve the matter without a formal indictment. If the target responds, the assistant U.S. attorney is likely to give the target an opportunity to resolve the matter with an information and indictment waiver in lieu of grand jury presentment. Click to view sample target letters in PDF format. Below are sample target letters from DOJ. If you are attempting to submit an SBA offer in compromise or workout to an SBA lender, CDC, or to the SBA in response to the official 60-day notice, contact us today for a free initial consultation with an experienced SBA workout attorney at 888-756-9969. We can analyze your SBA loan problems and advise you on potential solutions.